Kwame, what the EOCO is trying to do now, and people have complained, but the EOCO is explaining that they set the bail terms to match how much it is alleged that the person has stolen. Now, we have been told that they have been going, EOCO is heading back to court to seek even tougher conditions for the former BOST MD. I mean, I've heard some lawyers say that's against the people's human rights because the Constitution enshrines that if you peg a bail condition above what the person can actually give, that becomes a difficulty. You are just deliberately trying to keep the person incarcerated.
Thank you, Kojo, and good morning to Ghanaians and CPP members, and especially our able Director of Communications, Osei Kofi Akwa, a hard-working gentleman who celebrated his birthday on Wednesday.
Okay.
If you go to Section 94 of the Criminal Procedure Code, it says that bail should not be withheld as a punishment, and the conditions shouldn't be unusually harsh. There are various conditions that are set there. And EOCO set the bail at 60 million. The lawyers had it varied to 30 million. The Human Rights Court agreed with the lawyers that it should be lower. And EOCO has gone back seeking for justification to be placed on the 30 million, which means that it shouldn't just be sureties. A surety is when you sign bail. If I'm granted bail, I can be asked to bring a number of people who will sign as guarantors, in quotes, in case I abscond, so that they will be pursued for the bail bond or whichever amount. So EOCO is saying that the sureties were not justified. That means we're not made to bring any property documents or other things that can be proceeded against in case the suspect, in this case, absconds. And of course, when you are setting bail conditions, it always has to align with the crime. It is not a figure that you just conjure up. In my experience in court proceedings, when a person is accused of a crime, the Honorable Court looks at the facts provided by the prosecution, weighs it against the charges. Because don't forget that the evidence is not before the court yet. So it is up to the court to weigh the facts and the charges and listen to the arguments of both the lawyers and the prosecution in order to arrive at what it feels may be fair and just in the absence of the evidence. So it's a very dicey discretionary power because anybody at all can be charged with anything. At the end of the day, the person can be found not to have done what he said to have done. So the court has to weigh all these things. So even though the practice is to set the value according to how much you are alleged to have misappropriated, the court also has to take into consideration whether it has been proven, whether it is likely to be proven, or whether from reading the facts, it is so clear as to be able to make a determination on it. I heard
but for example, in the Osei Sibe case, the National Service, the former National Service Secretary at BOST, the court varied it from 800 million to around 600 million. But the lawyer's argument is that, I mean, compliance would require that they pledge dozens of high-value properties in Accra or over 1,000 houses in Kumasi, making the terms, quote unquote, impossible to meet. And I was having a discussion with a lawyer yesterday. And he said, if you do that, that's like you're saying, I have given you the bail, but I know you can't meet it, so I'll still keep you there.
Oh, yes, yes.
Which means infringing the person's right.
Of course.
To free until he's proven guilty because you are they say what? You are innocent.
Innocent to proven guilty.
So why mustn't that guide how bail terms are set? Because 623 million with sureties. How is that? How is one person going to meet it?
It seems quite draconian. But then again, the courts have the discretion to look into it, and our legal system is fraught with some of these infractions, which we are gradually getting rid of. And I think this case should probably call for reforms in the bail sector. Martin Kpebu had this case a few years ago, Martin Kpebu versus the Attorney General, where the Supreme Court struck off part of the
bail that every case is now bailable.
Exactly. On one hand, every case is bailable, and on the other hand, if you stand as surety for somebody, you are in the past. If you stand as surety for somebody and the person absconds, then you also were slapped with some stringent requirements that made you look like an accused person. You managed to have those things struck down. So as we go along, we make reforms in our bail sector. So I believe that it is true. It may be the equivalent of 1,000 houses in Kumasi or whatever it is. But
1,000?
Yes, yeah, that's the argument the lawyers.
But the thing is that
623 million.
The thing is that if the prosecutor authorities have proof that that money has been lodged somewhere or spent somewhere, that they believe this person can marshal people who may have conspired with him or enjoyed some of the proceeds. They believe that they could be able to marshal some property to that amount.
Okay.
But then again, the cardinal principle is innocent until proven guilty. You see, so that is why the court has that discretion. So okay. I think that so far the bail terms, I think it's been a bit astronomical. Okay. Before this period, I hadn't come across. I think the last bail term that was a bit high. It wasn't up to this. Right. But as we go along, we can do the reforms.
Let me bring in Apia Danko here. So, I mean, from where both you ended, the fact that in the wisdom of the court, probably the monies that is alleged to have been stolen, you could amass it from people that, quote unquote, maybe you share the money with. Isn't that the court or the people prosecuting this then impugning guilt, even because the conclusion is done by the court that whether you are guilty or not?
So, my personal view on this issue, and I have a very strong view on this issue, is that our fidelity as the vanguard of the principles of our constitution, of our constitutional democracy, is on trial here. Because this issue happened in the Chema Wuntumi's case, where even though he wasn't charged as of that time, Chema Wuntumi was kept in cells for more than 48 hours without he being presented, having been the court. Now we run a system which says that one of the principles that's supposed to fuel how we act is the principle of the rule of law. We run a system that claims that its purpose is, amongst other things, to protect our liberties. And to achieve that, we are saying that under no circumstance should any Ghanaian be kept in cells or liberty be denied him for more than 48 hours without the order of the court. Now, what does this mean? Does granting bail mean that you fulfilled the terms of this law? Because in Chema Wuntumi's case, he wasn't charged. Provincial hasn't been charged.
I haven't read it. I'll check it.
He hasn't been charged. So, in both of their cases, under the law, they are not supposed. Their liberties are not supposed to be taken from them for more than 48 hours without a court order. Now, does this mean that by just giving them bail and giving them those bills under very onerous conditions fulfills the requirement of the law that says that you should not keep anybody in cell for 48 hours without a court order. And my opinion is that by granting them bail, and the bill here is a police inquiry bill, also. The bill they were granted is a police inquiry bill. It's a police inquiry bill. And giving them bail in such terms flouts the clear terms of our Constitution. That's my honest view. It flouts it. Because by granting them bail in the terms they grant them does not substitute for not keeping them in cell for over 48 hours.
I'm told this guy, Provincial, was held for 8 days in custody at the EOCO.
Chairman Wontumi was held for about 7 days. And in both of their cases, after the 48 hours, they purportedly granted them bail, but in such terms that they could not fulfill against the clear terms of our Constitution. You understand? So if they're going to hold them beyond 48 hours, then the right thing for them to have done was to have taken them to court, for the court then to charge them, and the court should decide whether to grant them bail or to let them go and the terms of the bail.
Okay.
So I think that's that's the first leg.
So it means that this guy, if you read the story, it's just investigation. He's not being charged.
He's not
so
being
if you
charged.
have not been charged, you should not be kept there for
more than 48 hours. If they're going to keep you for more than 48 hours, then they ought to take you to court. If you don't take it, how can you keep somebody for more than 48 hours without taking the person to court? And then you slash a bail under such onerous conditions. So it's like so that they are weaponizing bail. Okay. They are weaponizing bail, and they are using to flout the clear terms of our Constitution and abusing the rights of citizens of Ghana.
Okay.
Yeah, understand? And you see, we tend to personalize things. So when it was Chairman Wontumi, because a lot of people have issues with Chairman Wontumi, people kept quiet. You understand? But whether you like Chairman Wontumi or not, he's a citizen of Ghana. And all the rights, all the principles under our Constitution apply to Chairman Wontumi as they apply to any other Ghanaian. Same with Provincial. You get a picture. So the principle that we all of us agreed to subject ourselves to under the 1992 Constitution is that nobody should be kept behind bars for more than 48 hours without taking the person to court. And a solution to that is not to give some bail and then you deliberately give some bail condition that the person cannot meet. And then you are punishing the person. You are persecuting the person. And you don't have the power to do that. You shouldn't have the power to do that.
But why isn't the court also directing such state institutions that you are wrong in doing that? Because, as I read, no charge has been filed. He's been kept more than 8 days. And the court only slashed.
So that's why you see the court cannot sit down and just be dipping their hands. Unless the matter is brought before the court, then the court can make a pronouncement on it. Okay. So in both their cases, they could have gone to court for habeas corpus, for orders of habeas corpus demanding that they are released because there's a fundamental breach of their fundamental rights under our Constitution. Now the second leg to this issue is now where they've been charged. Now where they've been charged, I think my brother did a fantastic job. Because you see, the fundamental principle there is that you should not treat bail as a punishment, as a tool to punish. Because for all intents and purposes, unless and until the court pronounces the person guilty, the person is innocent. You get a picture. And so you should not deliberately then use bail as a means to keep people who are presumed to be innocent. Of course, when the person has been charged and you are giving bail and you are setting the conditions, there are certain principles. Does the person have a high risk flight risk? Yeah, so when we are applying for bail, there are certain things that we prove there. Because the courts give clear indications of what you should consider when you are granting whether you are granting bail. And one of those conditions includes the nature of the offense that they are being charged. but also whether they have a permanent place of abode, and the thinking there is, are these people who are likely to run away? Will these people come to court when they are asked to come to court? They are the key things that you consider, whether to grant the person bail or not. So that if there's evidence that suggests that the person will run away, you understand? Then you, the judge, you may then decide to use your discretion not to grant the person bail. You understand? Now the question is whether or not, so because one of the key considerations is the offense that the person committed. Where the offense is stealing. Of course, I'm sure the amount of money the person is being alleged to have stolen may influence the bail condition you give. But the underlying principle is, will this person come to court when I ask the person to come to court? If in spite of the amount the person is purported to have stolen, you are convinced that this person has low risks, low flight risks, it does not make sense to give a bail condition that you yourself ought to know that it's practically impossible for the person to meet that bail. Then in that case, you waded into the arena of using the weaponizing bail and using that bail to punish somebody who, for all intents and purposes, is presumed under our constitution to be innocent. Yeah. And we cannot allow this flouting of the principles that underpins our constitution. Then the objects for why we took upon this our constitution will be undermined. And no circumstance should those objectives be undermined. Those objectives being a guarantee or a protection of our right to our lives, a protection of our right to our liberties, a protection of our right to pursue our individual happiness. Yes,
how must we cure that?
And that's what I said, for me, these principles are, or our fidelity to these principles are under trial. Because when we passed the constitution, in the constitution, we thought that because, for whatever reason, based on a checkered history, we thought that we need to teach our people to align to these ones. And that's why we formed the National Civic, what's it called? NCC,
National Commission
on Civic Education. Well, when you go to other constitutions, when you go to the US Constitution, you don't see National Reason for Civic Education. You go to Britain. But in Ghana, we thought that, listen, what you show, you understand? So let's put in our constitution a provision that will train us, you understand, in terms of the principles that underpin. So for me, it's a matter of training, because clearly our fidelity to these hallowed principles that ought to underpin our constitution is lost. Okay. All right. Yes, so NCC has a lot of work to do. Okay. If it means incorporating this into our curricula, as in, so right from primary school, we train our people, you understand, in line with the principles that underpin
but is it their job to do that when organizations like EOCO, the boss that is even justifying that, look, what we are doing is that we are pegging the bail terms to how much they are alleged to have stolen. Yeah. Is it the NCC to educate our citizens or the organizations that are charging or that are placing these bail terms on people?
Our constitution is how many years old? It's 33 years old.
Yes.
How old is EOCO was? I don't think it's 60 years old. So if NCC was doing their job right, those principles have been so inculcated in him that in how he delivered his or he discharged his duty, you have regard to these principles.
Okay.